All right, so chapter 15 really sort of summarizes that we've spent all these years accumulating assets and wealth, and we can't take it with us, as you know. So there are other steps that we can take while we're living to make sure that these resources are well cared for, and so that's a big part of it here. So that's really the purpose of an estate plan, is to make sure loved ones, families, your family members are the beneficiaries of any accumulated wealth and assets that you might have, that you intended for them to have. And that's why it's important that you write it down, because what you intend to happen might not necessarily be how the probate laws play out. And so that's another really important type of thing. But in addition to having, basically we're going to be focusing in on the role of a will, in all of this, which is critical. But that's not the only thing you need. That's not the only thing you need. Okay. You are also going to need, if you, you're going to need basically a medical directive who's going to make decisions for you in case you become medically incapacitated, that you can't make decisions. And you're also going to need a power of attorney, a durable power of attorney, to appoint someone to take care of your financial assets, pay your bills, other things. If you are still living, but you can't do it, you're incapacitated. So those are other things that are really critically important here. And another thing I will touch up on very briefly is simply the types of trusts that a lot of people can use, even those that have modest means, and can help shelter their assets and save a lot of headaches as well down the road for your loved ones. Okay. So again, the key word here is planning. A lot of people don't like to talk about the fact that we are going to pass someday, but we're the only living beings that know. Animals don't know. You know, they don't know they're going to die. We know we're going to die, so we can actually plan ahead. You know, and so that's one of the most important things. And of course, it's not a pleasant topic to talk about. I understand that, but it is something that is related to financial planning, and it's very important because if you're spending all this time planning and building wealth and not planning anything after that, well, that's you're missing part of the plan. So might as well finish it off. Okay. So again, it's really the final step. What's going to happen to all your stuff? And you have a chance to actually look at that. So two basic parts in terms of, what's going to happen with the people who you love and you take care of. And second is what's going to happen to all the assets that you own, um, and where's that going to, right? So again, it's really two parts because for folks, I mean, I still have kids, that are young enough where uh, you know that if something happened to me, I would be very, very concerned about their, psychological, financial, other types of needs. I would want to make sure that there's enough assets in place to make sure that they're beneficiaries of certain things and that they're getting things taken care of. Um, I also have a spouse that I want to make sure, is also reasonably assured that they're going to have a place to live and all this other stuff, not to worry about those types of things. Okay. Um, and so part of it is I have to also look at, as everyone, what assets do you have? What's a list of your stuff, all your assets that you own? Do you own them all alone, or do you own them with somebody? That's a joint property, or is it solely yours? For joint property, the form of ownership basically covers the transfer of an asset. So if you own a house with your spouse and you're both joint tenants on that house, then clearly if you pass, it goes to the other person. and that's part of the law. So that's, in essence, that's part of that planning that you have to think about. But that's not usually true of all your other stuff, whether it's your car or if you have a collection of, various things, whether it be jewelry or art or other types of things. Those are privately done. And so who's going to take over that? And that's why it's important um, to understand what your assets are and what you want to happen to that when you're done. In many cases, it does come down to planning for other people to take care of. Some people have so many assets that not only do they feel the people close to them are all taken care of, they have a lot of extra that they want to give to charity or other types of things. So there's a lot of thinking to be done about this that actually can be quite beneficial. All right. So again, I'm not going to go over the 7 steps, and I'm not going to go over the 7 dwarfs either. What's your family situation? What's the data? What are your assets? Because the assets basically become your estate. Okay. And so, when you pass, one of the things that happens is, okay, what's your estate? What are all the assets that you own? So that's, from bank accounts and stocks and bonds and real estate and other property, personal property, real property, other types of things. All of that is your estate. Okay. Now remember, you can't pass debt on to another person, but your debts are going to be paid from your estate. Okay. Before the other people are going to get what you want them to get. And so if you do have a lot of debt with various things, those debts are paid from the assets in your estate. And if you don't have anything left after that, then whatever beneficiaries you wanted to get your assets are not going to get much of anything. That's not true for everything. Like I said, there's joint property and other things that automatically pass. But for other things, it might be effective. Okay. You need to understand that you're going to need to designate beneficiaries who are going to get your assets. And there could be a number of beneficiaries that are involved. And that's why it takes a lot of thinking to see, okay, who's going to get what? Who's the real beneficiary of this, et cetera. There are certainly for folks that have a very large amount of assets, there are going to be costs that are involved. For most of us, there's usually none. And then formulating the plan is basically why we put it down on paper in a will. And they can be implemented through the appointment of an executor who will make sure that your plan is going to come up and be done accordingly. And then, of course, you need to review that plan, yearly or so, just to see if anything has changed or if you're okay with that. And if not, you can revise it. All right. So again, your gross estate, all the property that you own is your gross estate. Okay. The probate estate basically is that part of your gross estate that's going to be transferred via your will. Okay, which is why a will is important. Or if you don't have a will, then it's the laws of your state that will determine who gets the rest of your gross estate that's not, say, jointly owned. Okay. The probate court takes care of all of these wills and estate issues. Okay. And that's something to understand. This is a legal matter. It's not just, oh, you died, there's nothing else to do. There's plenty to do. Plenty to do, plenty to plan for. Okay. The balances of your assets in your gross estate are transferred to the beneficiaries. Okay. Or if it's property, then it automatically transfers to their owner. You need to get another deed done once that happens. So a will is basically that written and legally enforceable document. It's a legal issue here that we're talking about. And your will is basically saying, this is what I own and this is how I want it distributed upon my death. Okay. And that will basically is going to be followed by the legal system, assuming it's done properly, which is why you should probably get a lawyer to do this. If you don't have a will, again, your state has laws, rules of intestacy, that basically, and I think I posted that on the System for New York on our website, but if I didn't, I will. But in New York, there's a planned set of actions of what who inherits what if you don't have a will. So wills have to, what they are basically is it's a plan for distributing your assets. You should also consider future changes in your family circumstances because you might get married, you might get divorced, you might have another child, you might adopt a child, I mean, there's a lot of other types of things. Normally, you want to make sure you are concise in what you want to happen, but also complete. You didn't leave anything off your list. You organize it as a layperson, but you shouldn't write it. It should be something that you can get help with from an attorney. So there's an example of your will, of a will in the book. It's the Exhibit 15-2. But there's a few things that are important to kind of know about it. First, in order for you to actually write a will, you have to have what's called mental capacity. It means you have to be of sound mind. You can't be you can't be totally out of it under the, like any other contract, you have to have capacity. And so, you can't be basically on your deathbed under an enormous amount of opioids and saying, yeah, I want to write a will today. It's just, you're not of sound mind. So this is going to be something that's done up front. Okay. The will has to be your choice. You have to make sure and testify that this is what you really want to do with these assets. This is what you really want to happen. You're doing this by choice. You have the freedom of choice. You're not being pressured by someone to do it. It's freedom of choice. Okay. And the execution is really important because it has to be properly executed by state law. Okay. You can change a will over time. A codicil basically is just for making minor changes to a will. Okay. And that's something that it's a legal document and it simply can be added. Anything that it changes basically revokes that part of the will. Okay. And changes it to whatever the codicil would have listed there. You should also include any last instructions, okay, in terms of carrying out your wishes. And that, would include making sure that somebody important knows where your will is. It's very, very important to know that you just don't make a will and bury it in the backyard, never tell anybody, because how's anyone going to know you have a will? It has to be, someone has to know where it is so it can be executed upon your passing. Some people like to put their funeral and burial instructions. Some people put other types of suggested types of things in terms of who they use legally, who their accounting professionals are, explaining certain things, etc. And that's sort of important. I mean, I don't personally want, I don't want much of a funeral at all, and so how's anyone going to know that if I don't write it down? Right? I want to be cremated versus it. How's anyone going to know that if I don't tell anyone or write it down? So a lot's very, very important to do with these instructions here. Otherwise, people are going to do what they think you need, and that might not necessarily be what you want. So the other two particular ones that you're going to need for sure with the will is you want to make sure that you can appoint someone who's going to take care of any financial issues that you need. So you need a power of attorney. Could be a limited power of attorney for financial matters. Power of attorneys can be quite broad, they can be quite narrow. It depends on what you want the person to do for you. Okay. But it literally is you're giving them permission to do something on your behalf. That's really what a power of attorney is about. And so if you say, if you have a power of attorney for financial circumstances, you are literally giving that person the right to say, take money out of your accounts, write checks, pay your bills, represent you in financial matters only. Okay. There are also durable power of attorney strictly for healthcare related decisions. And that's also very, very important to understand that should you become incapacitated, because as we get older, you just don't know how we're going to go. Could be very peaceful and or it could be, you could have several pipes in you, you're going out like looking like an accordion. Um, and so it's very important if you're in a bad spot to have someone have a legal authority to make healthcare decisions for you. And that's what's really important to understand. Otherwise, you need to understand that hospitals they're under legal obligation to keep you alive as long as possible. Okay. They have to take every means possible to keep you alive. That is their legal obligation. Otherwise, they're liable for that. That's a legal issue that they can get sued for. So it's important if you don't want to be resuscitated to state so legally. If you want to die naturally, to state so legally. That covers your wishes, and it also covers, the healthcare provider, so they don't get sued for following your wishes. So it's very, very important legal matters that actually have a financial impact on everybody. When you do have a will, you need to find someone who's going to be your legal representative. An executor, it's basically your legal representative to make sure your wishes that are expressed in your will are carried out. Okay. Depending on the size of your estate, it you could actually hire a legal company, an attorney to do it for you, or a legal firm to do it for you. Sometimes this is one of those things. Traditionally, it's always been the oldest sibling takes care of the parent as the executor. It's really, you shouldn't look at it that way. Whoever, it's a legal process, it's a financial process. There's a lot of things to this. So it may not necessarily be that the oldest sibling is best suited to carry all that stuff out. Maybe they don't have that type of a view. Maybe it's one of the younger siblings or a cousin or that's trusted who has that background who will actually do the job well for the deceased. So appointing an executor should be something you talk to the person about before you do it. Otherwise, it's a big job. It's a huge job. Okay, the bigger the estate, the bigger the job it is. Executives can't get paid. They often take a percentage of the estate as payment. But it's your legal representative to make sure all that stuff is getting done. Okay. Again, some things don't have to be worried about in terms of ownership of property. The transfers can happen automatically. So joint ownership with right of survivorship, at the death of one owner, the title passes directly to the other owner. No additional action is required, etc. Tenants by the entirety, basically, it's usually subject to husband and wife. And I think in many states now, it'll be husband and husband, wife and wife as well. So it's specific to married couples. And again, that title passes to the other upon death of one. But it's strictly for married couples who own property, tenants by the entirety. The thing is with tenants in common, there's no right of survivorship. So if you are a joint owner with someone and it's tenants in common, then your half of the house, for example, is not their half of the house once you die. It's actually subject to the will and probate. So if you've promised it to your very favorite daughter or son, then that might become a surprise to the other owner, but it's perfectly possible to do through legal means. Okay, so this talks about community property again. Just more again, marital property for most states, even in a community property state, is an equal co-ownership. All right. Last thing we're going to be talking about here is the role of trusts. Um, so trusts are basically, in essence, they're their own legal entity, very similar to how a corporation is set up. A trust is set up as a separate legal entity, separate from you, even or if you were married, separate from the couple. And what happens there is you set up a trust, and then you transfer property into the trust for the benefit of someone. Okay. Of course, you can be the only person that all this benefits, or it could be you and a spouse. It could also be a family, whatever. But the person who actually creates the trust is called a grantor. They're the ones who are creating the trust. It's a separate legal entity for the benefit of somebody, right? Someone who's a trustee is a person who administers the trust, okay, based on the trust agreement. Um, and so it could be the same person, it could be a different person. Oftentimes it is the same. And of course, there are beneficiaries, the people who's going to be receiving the benefit of that trust, either the income it provides or the use of property if there's real estate in it. And so I had my parents do this some time ago, set up a living trust where they put their house and all their assets into the trust because it protects them. It protects them in the case that they get disabled and need to go to a nursing home. If that happens to people, believe it or not, nursing homes are very expensive. And if you don't have any care insurance, it's very unlikely you're going to cough up $120,000 a year to keep someone in a nursing home. So oftentimes you can get insurance through Medicaid, but they're going to seize your property. They're going to take your property to sell it, to use it to fund and take care of you in a nursing home. This stops that from happening because you don't have any property. The trust owns the property, and you're simply a beneficiary of the trust. And so you're living in the house because the trust owns the house and the trust is set up for you to live there. So that's how I set that up with my parents as well, where they have a trust. They are the trustees as well. I am also a trustee. But they are the beneficiaries of that trust. In other words, they're the ones who use the property now while they're living. And once they are no longer living, then I'm the beneficiary. And then I will also assign my children as beneficiaries after that. So these things can last a long time. And that's one of the benefits of trust. They don't have to end when you end. And so it's important. Two types of trusts are going to be looked at as well in a moment. But here again, this talks about why people use trust in the first place. But again, it's a very nice legal way of managing and conserving property for a beneficiary. Okay, and so that's very, very important. Trust agreements are not public, whereas anything that happens in a court mostly is public information. Okay. And so make sure that too, in the types of trust you have, you need to select trustees for that. And again, they need to sort of have a really good head on their shoulders to manage this properly. But this is what I really wanted to talk about here is Just the types of trust that most people can use, even those that have modest means. Revocable trusts, like the living trust that I have my parents set up, basically a revocable trust can be dissolved at any point in time by the grantor. So if the grantor who creates the trust 5 years later says, I don't want the trust anymore, they can revoke it. In other words, they can dissolve it. It doesn't exist anymore, and thus there's no beneficiaries to that anymore. That's not the case with an irrevocable trust. Once you set up an irrevocable trust, it lives on forever. The grantor can't change it. Okay. And so that's one of the more important things. But for a lot of people, particularly have parents that might end up, or you feel you may at some point end up with some health issues that might put you in a bad situation, and you're not a wealthy person and can afford private health care. This is a really good way to sort of protect some of those types of things. And you should be discussing various options with a financial planner or an attorney or both, who can sort of help guide you through this big system that's there. But there's a lot of really good things available for you on that regard. All right. That was the tour, chapter 15. Any questions?